So what's the difference between a last will and testament and a trust? Well, folks, first of all, the last will and testament. This is a written legal document that disposes of the assets of the maker at the time of their passing. And in general, the will must be in writing. The person who's signing it must be competent, must understand what they're signing, and be above the age of majority. And the will must be witnessed by two disinterested parties. Parties that are not involved in the estate or named in the will. Now, the will is going to designate a manager of the estate called a personal representative. That person used to be called an executor of the estate. That's been changed in Massachusetts. And it's also going to designate people to take from the estate, called devisees or heirs to the estate. Now, if there are minor children involved, then guardians for those children can be appointed through the will, as well as assets can be held in trust for the benefit of those children until they reach the age of majority or an age that the maker designates through the will. Now, flashing forward to the trust. The trust is, once again, a legal written document, and it holds assets for the benefit of others. Now, the maker of the trust, called the donor or the grantor, all the same person, can appoint a manager of the trust, and that manager is called the trustee. And also the trust will name beneficiaries, people who are going to take the assets from the trust. Now, this trust can be formed while the maker is alive and can go into effect while the maker is alive. As a matter of fact, most trusts are funded while the maker is alive. By funding, that means assets have to be transferred into the trust to be held. Whether it's money or real estate, the trust can hold those things, and the trustee will act as the manager for those assets while the trust is in effect. When the maker passes away, the trust can have a provision in there that says that the assets will then be given to the beneficiaries. And it can be structured like the maker's will, but the difference between the documents is you don't need court involvement, and it can be funded during the maker's lifetime, and it actually can operate during the maker's lifetime. So the difference between the documents are that you need the probate court for the will, and it only comes into effect when the maker passes away. The trust, on the other hand, is a legal document that will hold assets during the maker's lifetime. And you don't need the court's involvement in general to administer or to divide the assets of the maker. Dave Ceruolo, CeruoloLaw.com.